welcome to our Prestige PEO webinar series. My name is Shannon Shaw. I am Operations Supervisor at Prestige PEO and your host this morning. Today we will be talking about the compliance updates on the West Coast. I am joined by Elizabeth Shaw, VP General Counsel, and Carrie Pallon, Associate General Counsel, HR Consultant. Our webinar viewers are automatically muted, but we encourage you to utilize the chat feature for any questions you may have, and we will address them at the end of the webinar if time allows. If your question is not answered, we will follow up with you shortly after the webinar concludes. The webinar is also being recorded and will be posted on prestigepeo.com/webinars so that you can refer to it at any time. And now we'll get started with the webinar. Welcome, Liz and Carrie.
Good morning.
Good
Thank you
morning.
so much for that introduction, Shannon, and thank you, Carrie, for joining me today for today's webinar. We are excited to be talking about our West Coast states and some things that have been happening on that front. But today we're going to start out talking about some federal employment law updates, some case law that we think you guys should be aware of. And then we'll end our webinar talking about some hot topics for this year and some things that we just see trending across many states. For those of you who joined us on our New York and Northeast focused webinar a couple of weeks ago, we are going to be covering some of the same information on the federal level and on the case law updates, but the majority of our content today is going to be focused on California, on Oregon, Washington, Colorado, and Arizona. So Carrie, thank you for joining us. For those of you who have not met Carrie, she is a recent addition to our team. She's been with us for a few months, rocking it on our, our legal side of things and on our HR side of things, and we are just so excited to have you with us, Carrie. So thank you so much for joining me on this journey of educating our clients about what's happening. So
happy to be here. Thank you.
Of course, of course. So we're going to kick it off talking about some federal employment law updates. So in 2020, the U.S. Department of Labor issued an updated overtime rule. So that rule set and adjusted the threshold by which employers have to pay non-exempt employees in order to not have to pay them overtime. And so this rule has now been updated and will be going into effect just in the next couple of months from now. But in August of 2023, the Department of Labor proposed some changes to it. And so what they'd said is we're going to increase that threshold on the federal level from $35,568 annually to $55,068 annually. And that roughly equates to $1,059 per week. So that's an important change because even though some states may have a higher minimum threshold for overtime exemption, a lot of states follow this federal law. And so it's important to be aware of it and to understand what is coming. So the comment period for the rule closed in November of 2023. And what it also did is the rule itself that was proposed, it created a mechanism so that going forward over the next few years, we'll see that annual threshold amount automatically increase so that you won't see an ongoing proposed rules have to be rolled out like this. So the final rule is slated to be released in April of 2024, and we anticipate that there will be a 60-day window after it's released before it goes into effect. So it is coming. It's something to be aware of, have on your radar. My guess is most employers who claim that exemption for certain employees likely are going to be meeting that already, but it's always good to check and make sure. And so just a reminder, be aware of it, plan now if you have to make adjustments, and just keep in mind that those state laws may require more of you than the federal law does. So good thing to keep in mind and be aware of. The Department of Labor also has been busy on the independent contractor front. This is an ongoing hot topic for really federal and states in terms of properly classifying people as independent contractors or as employees. Remember, it's one or the other, not both. And so what the Department of Labor has done is they released a final rule in January of this year. The rule is effective March 11th, 2024, so coming up soon. And what it does is you kind of see this, as politics change and who's running our country changes. A lot of times these administrative agencies are impacted by those changes. So you'll see this flux of standards be adjusted every couple of years to either be more employer friendly or, potentially more employee friendly, or in this case, more friendly to the worker in terms of making sure that if they are supposed to be classified as an employee, that they are being. So this rule restores a 6-factor totality of the circumstances test. I'm not going to read off every single one of these here, but just know that before they were placing a lot more weight on just 2 of these factors, but now they're going to say all of these things can impact whether or not someone is really an independent contractor or not. And quite frankly, if it's looking like they're an employee, you should be classifying them as that. So it's important to keep in mind this rule is coming out, and if you are using independent contractors, to take a look at whether or not they are properly classified, because the penalties for putting them in the wrong bucket and not paying them overtime if they're entitled to overtime, or giving them other benefits that they might be entitled to, can be substantial and certainly can impact your bottom line as a company. So, sorry. Anyway, so that's what's happening on the Department of Labor front. But Carrie is going to talk to us about the NLRB. So, Carrie, what is happening there?
Thank you. And good morning, Liz. Good morning to everyone again. Thank you for joining us. Yes, as Liz stated, the National Labor Relations Board has issued a new joint employer rule that has an effective date on February the 26th of this year. Now, similar to what Liz was talking about before, the NLRB is made up of political appointees who do serve for a few years. Therefore, they are subject to the contemporaneous political environment. Currently, the NLRB is more employee friendly. The new joint employer rule replaces a rule that was issued in 2020, so the prior administration, which was more employer friendly. This primarily impacts employers that are franchisor, franchisee type of agreements. However, other employers need to be aware of the possible impact the rule does have on their business. So this new rule states that an entity may be considered a joint employer of a group of employees if each entity has an employment relationship with the employees and they share or co-determine one or more of the employee's essential terms and conditions of employment. And then it goes on to list out what some of these terms and conditions of employment could be, and these include wages, benefits, and other compensation, hours of work, including scheduling, the assignment of duties to be performed, the supervision of performance of duties, work rules and directions governing the manner, means, and methods of the performance of duties and the grounds for discipline, the tenure of employment, including hiring and discharge, and another factor that is taken into consideration is the working conditions related to the safety and health of the employees. So the NLRB released a fact sheet about the new rule. It's embedded in this webinar that you can find attached to it. So.
And we always post our webinar slides online, and certainly if you need access to this, check with your HRBP, who can also help you get to it. But the interesting thing here, Carrie, and I think you touched on this, is, the NLRB ebbs and flows just like Department of Labor does in terms of the fact that there are political appointees. The NLRB every few years, they operate a little different in that they are on some kind of rotation basis. And so, it's not that everyone is in and out at the same time. So now we're seeing a much more employee-friendly NLRB. And so what they're trying to do is really expand this reach of who they're trying to hold accountable for what's happening in the workplace. But the interesting thing with the whole political aspect of this is earlier this month, Congress, the House specifically, came out and they were like, Mm, we do not like this rule, NLRB. In fact, we are going to pass a resolution saying that we're going to be trying to shut this down. And so it's interesting to see that push and pull. And if Congress steps in and acts and they say, no, 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 this is not the standard, NLRB, we're not going to let you do this, then that will trump what this administrative agency is trying to do. So it's always interesting when you're talking about what's happening on the federal front to see this push and pull, the NLRB trying to do something, Congress saying, no, we're gonna try to step in and stop you. Like it's always interesting, but in the middle, you always have the employer who's trying to be compliant, who's trying to do the right thing, and it does make it difficult to keep up with what's the standard and what am I held to? And so, unfortunately, we'll have to see how that one plays out. That issue is not resolved yet, but we'll certainly see what happens. So that's it on the federal front in terms of things that we think you should be aware of right now. Obviously, with this year being a pivotal year in terms of election and stuff, it's going to be an interesting ride. Everyone hold tight. We have survived them before, we will survive them again. And so right now, though, let's talk about case law, because there's a couple of cases out there that I think are interesting for employers to be aware of, because sometimes you have your administrative agency who's trying to do things, then you have Congress who's doing things and putting laws into place, but then you also have the court system that's saying, this is how we're going to interpret all these laws that have been passed. And the push and pull of that process is very interesting. As an attorney, obviously it's interesting to me. It might not be interesting to others, but here we are with a case that came before the Supreme Court in December for oral arguments. And that's the case of Muldrow versus the City of St. Louis. So this is an employment law case dealing with Title VII, which is the federal law that oversees the protection of certain individuals based on their protected classes against discrimination and retaliation. And so this case arises out of a situation where we had, just a little bit of the backstory, we had a police officer who was in one department. She got moved, so it was a unilateral move to a different department. And she ended up bringing the suit saying that she was discriminated against based on her sex. And her allegation is that, yeah, it was a unilateral move, but I didn't have the same opportunities I had before. Yes, I was being paid the same, but it really didn't carry with it the same amount of clout as I had before in my prior position. And so she was basically saying that just the fact that she felt she was discriminated against based on her sex, that the fact that there was a decision that was made in the context of employment that had, an impact on her, that was enough to bring this claim. And so that's the question before the Supreme Court is really, do you have to show that there was a harm to the employee in order to bring this type of claim? And what is interesting is up on appeal, as it moved its way through the appellate process, the appellate courts were like, nope, this isn't enough. This isn't enough. But when it came before the Supreme Court, in oral arguments, they were sympathetic to, or it sounded like they were sympathetic to her plight. And so the reason why we're talking about this, this case today, is that if the Supreme Court comes out with a decision, which would be likely released in June of this year, saying that you don't have to have a showing of harm to be able to prevail on a Title VII case, that is going to be a big and, quite frankly, unfortunate impact for employers, because then the bar for bringing these types of claims is just that much lower, and it becomes even more difficult as employers try to make decisions in the workplace for what they can and can't do, and that risk of exposure is just that much higher. So on that front, I think it's important to be aware of this case. We'll see what the court says and how they come down, but it's one of those situations where it's super hard to be an employer and super hard, to avoid, um, you know, potentially and being involved in litigation, but this would make it even more so hard for employers. So we'll see what happens with that case. But Carrie, go ahead and talk to us about this next case.
Certainly, certainly. The next case that we wanted to highlight today is the Eisenhower versus Culinary Institute of America. Again, this is again a very recent case. It was filed in 2019, and it's kind of tracked its way through the court system at this point. This case involved a female instructor at the Culinary Institute of America who alleged a pattern of pay disparity over the course of about a decade and a half between her and similarly situated male colleagues. So she had been an instructor there for a while, had a background there, and then she was joined by some male colleagues who then she alleged were making more than her. What's interesting about this case is it's a federal case that involves both the federal Equal Pay Act as well as New York's Equal Pay Act. The plaintiff alleged again that the employer violated both laws by paying her less than her male colleagues. The court did note that the federal EPA allows for the unequal pay if it's based on any factor other than sex. The New York law, however, Liz, goes further and adds the additional requirement that the factor other than sex must be job related for the position in question. So again, there's that more protection for the employees. So while the defendant prevailed under the federal EPA, the appellate court clarified that these statutes were very different, and they remanded the matter back to state court under the state's Equal Pay Act, which had that higher standard that's noted above. So this case serves again as a reminder that state laws often have more protections for employees than federal laws. So as an employer, you're being held to several different standards. So we have to be cognizant both of the federal implications of the various things that we do as an employer, as well as the state, certainly on a number of levels. So again, this case is just a reminder of that.
Right, especially as we become a more mobile society with more remote workers, it just becomes that much more difficult to, keep tabs on all of the different things that an employer should be doing. But that's why we're here. We're here to help, manage the chaos as much as we can. And so now we're going to talk about some state law updates so that you as the employer are in the know as to what's happening in some of our West Coast states. So we're going to start with the one that seems to like to get most of the attention on the employment law changes, and that's our friends in California. California, by and large, passes the most laws every year for employee protections. They are constantly upping the game, and so, I always have mad respect for those who are brave enough to have employees in California. And so let's start off with something that they passed and that went into effect at the beginning of January 2024, which is their enhanced paid sick leave. So a little bit of backstory, California has had paid sick leave for many years now. They were kind of leading the charge for, most states didn't offer paid sick leave. Now we see a lot of states offer it. So now we just are seeing them kind of up the game a little bit, increasing those benefits. So before on the state level in California, it was only required that you offer paid sick leave of 3 days, each year. But now they're increasing that to 5 days. And then there was also an accrual cap that employers could put in place. And before it was only 6 days, now it's 10 days that employers can cap. But kind of the nuance here for the paid sick leave is the fact that employers can still put in place these caps for how much an employee can accrue, but they can also still limit how much the employee can actually use every year, which I think is kind of, in my opinion, it can feel like a strange rule to have in place. Like, there's all these different moving parts. But I think the takeaway is that before you could limit it to the 3 days, now you can limit it to the 5 days, so that matches that increase. But it's also important, I think, to keep in mind that one, if you live in a locality in California that has their own sick leave rules that are more generous, that you still need to comply with those. But if they are less generous, then you need to follow this increase in California law. And then I think it's important to keep in mind that if you haven't updated your handbook policies, now is a good time to do it, to capture these changes in the caps and in the amount that they can use, both so that the employee is aware of what's available to them, but also so that as the employer, you can make sure that you do have things in place like the caps so that you can really limit employees' use of of these types of benefits, and make sure that you're controlling what is happening in the workplace. You also want to make sure your managers and supervisors are in the loop on what has happened as well, because they're the ones on the front lines. They're the ones, unfortunately, who from time to time step in it on these types of things, and so keeping them abreast is really important. I think I covered everything there, Carrie. Did I miss anything?
I don't think so. I don't think so. Just to reiterate what Liz said, it's certainly important to make sure that our managers that are actually granting that leave understand that leave. So
Exactly.
again, updating everything. Absolutely.
Exactly. Yep.
Again, yep. And, leading the charge on the forefront again is California with an additional type of leave that is protected at this point called the entitlement for reproductive loss leave. So this is effective January 1 of this year as well. And again, this new law provides eligible employees with up to 5 days of leave following a reproductive loss event. And again, this applies to all employers with 5 or more employees. And the employees must have been employed for at least 30 days prior to the commencement of the leave. Just a little nuance in this one. Now, while the protected leave need not be used consecutively, it must be used within 3 months of the qualified event. So if the employer, and again, expanding it a little bit more, if the employer suffers multiple reproductive loss events, the new law does allow for a maximum of 20 days of protected leave over a 12-month period. All protected leave is unpaid unless an employer already has an established policy providing to the contrary, but the employee taking protected leave must be permitted to use any acquired sick or other vacation time. So then the question becomes, Liz, what is reproductive loss? What is defined? How is that defined?
Right.
So the law does go on to define it to mean a failed adoption, a failed surrogacy, a miscarriage, a stillbirth, or an unsuccessful assisted reproduction. So if the employee, it states, would have been recognized as a parent if the aforementioned events were successful, then the employee would be covered under this definition. So again, California leading the charge on some of these newer laws.
Right.
This is another protected leave law.
Right, and I think it's always important that when I think reproductive loss, I might think that it's one thing, and it could be that, but that doesn't mean that that encompasses everything that the state is saying it does. So thank you
Exactly.
for clarifying what it covers, because you wouldn't necessarily know that all of those things are covered under this
Right.
law. So
Exactly.
good to know. Way to keep us on our toes, California. But also, I do think that it's always nice to do good things for your employees, and certainly a reproductive loss is something that is going to be a pretty difficult thing to recover from. So I do think it's nice to see some more benefits for employees, to be able to deal with what's happening outside of their work. We bring those things into the workplace, unfortunately, and it is what it is. So hopefully that time off for employees who are impacted by that type of a situation will be good for them and allow them to come back stronger, as they, get back, into the workplace. Okay, so let's talk about the updated wage theft prevention notice. So California has had a wage notice for a long time, and it covers some basics: what the employee, is making, the rate of pay, the pay dates that they can anticipate when they start, and it really lays out some foundational information for them so that everyone's on the same page as to how much they're expecting to make in this position. But California has updated this wage notice, and what they have added to it is a section on the new workplace violence policy that we're going to talk about in a minute, and also some information about paid sick leave and how that's accrued. So, when employees are onboarded with us, through Prestige's onboarding, they do receive this form, but it's just important to know that it has been updated. This is how it looks on the face of it, but there is a page 2 that covers that paid sick leave and other notice requirements under state law. So just keep that in mind so that you make sure that you are in compliance. All right, so Carrie, talk to us about this workplace violence
Yes.
plan that
Yes, again.
is coming
Okay.
soon, right?
Very soon. Yes, it will be. If you will have to have your workplace violence prevention plan in place by July 1. This is a new law under the California Labor Code that requires nearly all California employers to establish, implement, and maintain an effective workplace violence prevention, as you mentioned, plan, as you mentioned. So under the new law, the covered employer must establish a workplace violence prevention plan that includes, among other things, the name or job titles of individuals responsible for implementing the plan, and the procedures, which include obtaining the involvement of employees in developing the plan and implementing the plan. And you can see from the list, there's a number of items here that the employers have to include, which also includes responding to reports of workplace violence and prohibit retaliation against employees who report the incident, to develop and provide training on the employer's plan, to correct workplace violence hazards in a timely manner once they are become aware of them, and for post-incident response and investigation, and for the employer to review and to update the plan for effectiveness at least annually or when a deficiency is observed or after an incident of violence. And I think this really is speaking to kind of where we are in 2024. And we're starting to see these types of plans implemented at a variety of levels. We've seen them we've seen them at the school levels. We've seen them in a variety of different environments. So now California is really making the push for employers to take note of these types of things and start implementing that plan again, effective July 1. And as mentioned on the prior slide, this is going to be information that you're going to have to communicate to your employees, get their input in developing it, and make sure that you're reviewing it annually so that it's updated and everyone knows what's going on. There's an additional component too here as well. The covered employers are required to record specific information in what's called the violent incident log about every incident response and investigation performed, and to maintain those records. So, and I think that's to utilize those moving forward. So when you do your review, you do your audit, you have an understanding of where your deficiencies may be, and hopefully, you can address those in a timely manner.
I find it interesting on this front, the fact that part of the goal of putting this in place is to collaborate with your employees and to talk to them about it and get their input and their buy-in. And I think that's important because when you're in an event like that, it's just that much more important that people know what to do. It's already a unsettling situation. So the more that they can know, the better. And I just did want to clarify, as far as the notice is concerned, I know, and I didn't mention it, and, forgive me, I should have, there is a section on there that talks about any kind of disaster alert for the area in which the employee works. That is something that employers need to be disclosing to employees when they onboard if there's some kind of emergency event that might impact them, like flooding or fires, that type of thing in the area in which they work. So something to keep in mind as well. California always keeps me on my toes. Lots of different things happening and always in flux. And to that point, let's talk about the changes to the COVID rules in California. So on this front, California has changed their COVID guidelines more times than I think I can count. It is kind of tricky to keep up with it, but before they had a 5-day rule for isolation. Now they're changing that again to more so focus on the symptoms that a positive person may be experiencing. So they still say they should stay home until their symptoms improve, but then now they can wear a mask around others indoors for 10 days. And so the new guidance really focuses again on those symptoms that the COVID positive person has as the determining factor as to how long they really need to be staying away from people. So I think we'll probably see them change these potentially again, but this is the current state of the COVID rules in California. All right, moving on to a fun topic and one we'll revisit later in the webinar, but Carrie, talk to us about non-competes in California.
Okay, so California law already made non-compete agreements generally unenforceable, but new regulations raise the stakes here. Under the new law, it prohibits employees from entering into or attempting to enforce non-compete agreements, which are void under state law at this point. Employers are affirmatively prohibited from entering into non-competition agreements, and the existing law established that non-competition agreements were void against public policy. So, but there was no affirmative prohibition in the past. So, or from attempting to enforce the non-competition agreement. So, employees, an important note here too is that employees have a private right of action to enforce the law, so they can go out and get their own attorney and certainly implement or institute rather their own lawsuit if they choose to, and can obtain injunctive relief, actual damages, and an award of attorney's fees if they do prevail. So,
oh my goodness.
Yes, and the new notice, so there are new notice requirements as well. That requires employers to notify current and former employees employed after January 1 of 2022, whose contracts may include non-competes, that the clause is now void. The notice must be in writing and sent to the employee's last known physical address and email address, and it must be provided by February 14th of this year. So it's really identifying the potential non-competes out there and addressing it to be in compliance with this new regulation.
Right. I find it interesting, this non-compete law, in that I feel like California is really trying to stretch their wings and try to impact, potentially people who are working in other states or such. And so I think it'll be interesting to see long term, what the impact of this law is, what the challenges will be, and legal challenges, to it. And quite frankly, long term, if we'll see any kind of federal intervention to streamline what employers can or can't do on this non-compete front, because a lot of states are trying. California, I think, has been one of the most aggressive that I've seen. I know New York tried to do something earlier this year or last year on it and got shut down at the last hour. But it's we'll talk about this a little bit more later, but this one's definitely an interesting nuance that's out there. So let's transition and talk about Oregon. I think we've had enough of California, and there are many, many changes. So let's talk Oregon and see what they've been up to.
Certainly. We'll head north a little bit here.
Yes.
So a couple of new laws in Oregon that we need to take note of. One is the leave of absence for active service of the state. So this is going to be a law that went into effect on January 1 again of this year. So it's a brand new requirement that requires employers to allow eligible employees who are military personnel who are called into active state of service by the governor of the state. Now that you may be questioning, what exactly is that? So that's going to be like, an example would be the Oregon National Guard and Reserves or any other state defense forces. So what does it mean for the employer? They must grant the employee the leave of absence until release from active state service permits that return to work. The employee can't be subject to removal or discharge from their position because of this leave, and the employer is not required to pay wages or other monetary compensation. However, the state of Oregon will continue coverage under any employer-sponsored health plan. So this is moving us more into line with what's done at the federal level with calls to duty, and certainly will put some of the burden back on the employer to make sure that they're properly complying with this regulation, because again, I think this is speaking to the times where we are, these National Guards being pulled in for anything from homeland security issues to emergency management type of situations. We're finding a lot of the weather-related issues are now, impacting communities in a much bolder sense. And so having these personnel on duty is something that is potentially going to happen a lot sooner than I think in previous years prior employers would have expected.
Right. So it doesn't feel like this law is unexpected to have happened. However, it's a little surprising that it wasn't already in place. I think you mentioned that to me, Carrie, when we were
It
like
does.
preparing for this. You're like, I'm surprised they didn't already have this, you know, because some states do. And so it's not entirely shocking that they're trying to make sure that their people who can help are available to help and have those protections in place to do so.
Right. And just another note on this that I found, the other 22 other states, as well as Puerto Rico, have active forces. So these are very, they're out there. More than almost half our states have these type of state guards. So we need to continue to watch. This is another one, Liz, that we need to continue to watch to make sure that we're on top of things.
Absolutely, absolutely. Okay. So Oregon has also been busy, I believe, on the bias crime victims
They have.
protections. And I think you have this one, Carrie.
I
So
do. I have
let
this
us
one as
know what's
well.
happening there.
Yes. So this is an additional uh, it's rather an expansion of the eligibility for protected leave. It's as of January 1, the state law has now expanded the leave for to include bias crime victims. So under the established law, employees have been eligible for crime victim leave as a victim of domestic violence, harassment, sexual assault, stalking, or even as a parent or guardian of a minor child or dependent who's a victim of domestic violence. So this new law is expanding the protected leave to what's called a bias crime victim. So a bias crime is a crime that targets individuals due to their race, their color, religion, gender identity, sexual orientation, disability, or national origin, and have been subject to a crime due to the perpetrator's perception of those characteristics. So you often hear of these in the headlines, Liz, called hate crimes. So this is now expanding the protected leave to victims of what would be considered hate crime. And what does it mean for the employer? Again, we have here that with employers with at least 6 employees in Oregon are required to follow the law. But it also, we need to be cognizant because these particular victims will now be eligible to apply and may be eligible for the paid leave Oregon coverage. So again, just staying tuned into that this does expand that current protected leave.
It's sad that we have to have these types of things in place, but you know, here we are. So Oregon's also been expanding some other employee rights. And so what they have done is they have put a focus on protecting employees who are raising concerns about safety in the workplace and providing some procedures that, you know, that they can follow that then marry with that a protection from retaliation. So what they have said is that they are barring employers from retaliating or discriminating against employees who refuse to work, to do work that would expose them to serious harm. And there is a caveat there that any kind of employee refusal to do work needs to be married in good faith, and that there is like no other reasonable alternative to, you know, to responding to that type of a situation. They've also outlined some industries and jobs that they would consider to be hazardous. So that is on this slide for you guys to take a look at. But then what they also have done is they have basically said that, you know, employees have a responsibility to notify their employers of any violations of the law or safety issues in the workplace and allow them an opportunity to respond and to correct. But at the same time, so there's that employee responsibility, but then we also have the employer responsibility to not retaliate against those employees for raising those concerns. And then if they do, um, it provides this mechanism for the employee to bring the concerns to the Bureau of Labor and Industries in Oregon to say, hey, you know, I raised this issue. This happened to me, you know, and here we are now. I have, you know, this potential administrative action against the employer. So I don't think that this is a shocking, you know, turn of events to offer this type of a protection to an employee. And, you know, I do think it's probably a response to different issues in the workplace that employees have raised. But I think a lot of employers want to do the right things. They want to provide safe, you know, environments for their employees to work in. But, you know, these protections are in place so that there is a mechanism where employees can raise concerns. All right. So Oregon doing some, I think, some good things and some, maybe surprisingly late things. But, let's move on to Washington and what they have been up to. So
Yes.
I'm going to kick us off and talk about some salary threshold updates for Washington. Again, these are effective January 1st of this year. And what it does is it increases the threshold for exemption from overtime. And so now employees have to earn at least $1,302.40 a week, or annually that ends up being $67,724.80. But interestingly enough, there is this rule does apply to computer professionals who have to be paid an hourly rate rather than a salary. But the computer professionals are exempt if they earn not less than 3.5 times the state minimum wage. So a little bit of a nuance there for computer professionals. I think that kind of speaks to the industries that are present in Washington. But certainly keep in mind what types of employees you have working for you, what you pay them, and certainly want to take a look to make sure that you are in compliance if you do have overtime exempt employees, that you're paying them these thresholds.
Yeah, and here we go with some more
More
modifications.
non-competes.
Non-competes, exactly. Exactly. So Washington is changing the way that they look at non-competes as well, and have made modifications to the minimum annual threshold for enforceable non-competes. So they're making them more expensive for an employer to enforce, if you will. So effective January 1, the minimum annual threshold for an enforceable non-compete agreement has increased. Non-competes are now considered void if the employee, if their annual salaries earned are less than $120,559.99, and independent contractors whose annual salaries earned are less than $301,399.98, as outlined on the slide here. So again, making it more expensive to enforce these. And if a non-compete agreement is found to be void, an employer can be liable for an employee's actual damages or up to $5,000, whichever is higher, along with attorney's fees and costs. So making these types of changes is imperative to any non-competes, because it can be a very expensive ramification, certainly if they do not. So something to keep in mind.
All right, so let's talk about Washington and their pre-employment drug testing for cannabis. Take it away, Carrie.
All right, again, just reacting, I think, to some of the changing laws on a number of other states' fronts. Washington has now implemented a pre-employment drug testing prohibition against off-duty cannabis use. So the new law prohibits pre-employment drug testing for off-duty cannabis use and prevents an employer from making a hiring decision related to that off-duty cannabis use. So the question becomes, how do they know, right? So it applies to all employers with a few exceptions, such as law enforcement, fire department, first responders, airline or aerospace industry, or safety sensitive positions. And I think that's very what would fall in line with common sense. But as far as the drug testing itself goes, it's important that employers are ensuring that their vendors are drug testing for drugs through methods that do not screen for those non-psychoactive cannabis metabolites, and are really still conducting only the allowed drug testing. So they're really eliminating those any tests that would otherwise be screening for the cannabis. And certainly there is the opportunity for employers to test when there's that reasonable suspicion of being under the influence while on duty. So that's still an important component here, is to understand that employers still have that right to drug test when there's a reasonable suspicion of being under the influence while on duty, and they're also certainly able to enforce a drug and alcohol-free workplace. So again, it's kind of walking that fine line, but really ensuring that the employer is being cognizant of all of these rules.
Okay, so moving on from Washington, Colorado has had some changes to their Power Act. And this one, there were a lot of different things going on. So we have a couple of slides about the Power Act in Colorado. But basically what this Power Act does is it amends the Colorado Anti-Discrimination Act, and it expands the law to apply to all private employers with at least one employee in Colorado. So we're going to see some updates to the standard and definition of unlawful harassment, and Carrie's going to talk to us a little bit about that. Updated some defenses employers can have to these types of claims, and see some expansion of the protected classes, record keeping requirements, and NDAs. So Carrie, there's a lot going on here. So kick us off and talk to us about what they have done with what it means to do or engage in unlawful harassment.
Certainly. So there's a new standard and definition for what Colorado considers to be unlawful harassment. The Power Act explicitly rejects the federal standard, and the federal standard at this point is severe and pervasive. So for any harassment to be unlawful in the state of Colorado, there's now a lower standard, which prohibits any unwelcome physical or verbal conduct or any written or pictorial or visual communication that's directed to an individual or group of individuals on the basis of a protected class. It's subjectively offensive to the individual being harassed and objectively offensive to a reasonable individual who's part of the same protected class. In other words, someone else in that same protected class would find that that was offensive as well. So that being said, let's see, we can go to the next slide.
There you go.
So for the conduct or communication to be unlawful, one of three things must be true. So the submission to the conduct must be a condition of employment. It has to be objective, or submission to the conduct must be the basis for an employment decision. The conduct must unreasonably interfere with the individual's work performance, such as that it creates that hostile work environment. And the Power Act further provides that the frequency with which harassment occurs and the nature of the work are no longer relevant in determining if it has occurred. So again, that severe and pervasive standard has been lowered, and pervasive meaning how often does it occur is really key here, because the frequency now no longer matters. It's the severity of it, if you will, Liz. So again, it's going to be really allow the court system and to look at these things on a case-by-case basis, and that lower standard really does allow for the potential for it to be very broad, if you will.
Right. And, just to expand on that, though, what are some employer rights that so they've given, employees some recourses, but what are they doing for the employers on this?
Yes. So they do have rights and certainly some of those responsibilities. So the employer has a right to assert an affirmative defense in a situation like this, certainly. But in order to do that here with supervisor's conduct specifically, the harassment claim, or rather the employer must, in order to assert that affirmative defense, has to have an established program that's reasonably designed to prevent the harassment. So this is speaking directly to a supervisor's conduct to a direct report. So if the employer has an established program that's reasonably designed to prevent the harassment, and the employer has communicated the existence of the program to all employees, and then the complainant, so the recipient of the alleged harassment, has unreasonably failed to take advantage of the program, then that is an affirmative defense that the employer can assert. And again, that is all is going to come down to documentation. Is there documented proof of the program and the existence of the program? Are there channels with which the employers are directed to utilize the program? And then is there any documentation or evidence, certainly, that the complainant has unreasonably failed to take advantage of it? So, is there any evidence they talked to anyone? Did they talk to a coworker? Did they talk to a supervisor? Did they talk to the supervisor's supervisor? So these are all things that will be taken into consideration.
Right.
All right, now moving on to non-disclosures. So the Power Act continues to change a couple of things on a number of different fronts, and one of those are non-disclosure agreements, or NDAs. So under the Power Act, the NDAs entered into or renewed on or after August 7th of last year, so 2023, will be considered void unless they follow the following six requirements. So they must be mutually applicable to all parties. So the non-disclosure portion of it obviously must be mutually applicable to both the employer as well as the employee. And it does not prevent the employee or prospective employee from disclosing the underlying facts of any alleged discriminatory or unfair employment practice, including the existence and terms of a settlement agreement, to select entities. So it does allow them to talk about it. And it explicitly states that a lawful disclosure does not constitute disparagement. So again, it's really kind of curtailing what can be written into these agreements. So if the non-disclosure contains a non-disparagement provision and the employer disparages the employee or prospective employee, the employer's rights rather are very limited. So again, it normally in a traditional sense, these things are written where the employee is precluded from any non-disparagement language. Now it also is including the employer. So any liquidated damage provisions within the NDA must be for an amount that's reasonable, proportionate, and non-punitive. And the parties are now required to have signed and attached to the NDA an addendum exhibiting compliance with the 5 requirements listed above. So some more changes again to be aware of.
Right, and certainly if you're going to be doing an NDA for these types of situations, we certainly encourage you to have a Colorado attorney who's familiar with these, requirements, be reviewing those to make sure that you're in compliance. Yes. So, all right. So moving on, just to kind of wrap up the Power Act, because there was a lot going on under this law, just know that it expands protected classes to include marital status, which we've seen in other states. So it's not entirely shocking that Colorado would add marital status as a protected class as well. And then this one I think is interesting and good to know. There's also an employment record keeping requirement. So now employers are required to preserve records of complaints related to discriminatory or unfair labor practices for at least 5 years. And so that's huge for employers to know. It's important to have an idea of how you're going to keep records of employee complaints. Employers also have to maintain what we call an accurate designated repository for all written or oral complaints of discriminatory or unfair employment practices, including the date of the complaint, who the alleged perpetrator was, the complaining party, and what the substance really, what was the complaint about. And so now more than ever for employers in Colorado, it's important to make sure that if you're receiving an employee complaint that falls under this of being harassment or discrimination, that you make sure you have your ducks in a row, keeping a record of what has happened, what you did with it as the employer to make sure that you aren't running afoul of this law. And certainly it's would be to your benefit to really think about how you're going to do this, to get those processes in place now, to make sure your supervisors are aware of the responsibilities here as well. And to make sure that if you have questions about how to comply with it, that you are consulting with your attorney, or you are also, more than welcome to reach out to your HRBP here at Prestige to learn more about what is required. Okay. So that Power Act had a lot going on. So we're going to just quickly touch on Colorado's Equal Pay for Equal Work Act. This went into effect January 1st, and it requires there to be disclosure and notice requirements under the state's equal pay, including obligation to provide notice to employees for each job opportunity. And actually, did I take that one from you, Carrie? I think it was mine. But sorry. Oh, there's a lot going on today, but and then also any kind of salary or benefit information. Make sure that the window that the job is available to apply to, that is out there, and any kind of disclosure obligations for the position that follow career progressions, and that there is an obligation to make reasonable efforts to disclose information regarding selected candidates to employees with whom the candidate will likely work. So keeping people in the loop as to what's available to apply to, and what opportunities are out there. So I think this kind of follows the pay type transparency laws that we've seen go into effect and just kind of puts additional onus on the employers to be transparent as to what they're doing in their workplace.
All right, and I will follow up with a final update we have for you from Colorado, which involves the Colorado Healthy Families and Workplace Act. And again, it's an expansion of a current act. So employees are now eligible for leave for 2 new types of absences. And again, as Liz and I have been talking about, I think a lot of these laws are being reactionary to what's going on in the environment, as well as environmental change, political change, et cetera. So this really is speaking to some changes that I think have been really at the forefront in the last couple of years with some of the weather emergency management type of situations. So this one is to grieve the death of a covered family member, to attend the funeral or memorial of a covered family member, or to handle the legal or financial matters in the wake of a covered family member's death, and to evacuate from their residence or to care for a covered family member whose school or place of care has been closed down due to inclement weather, the loss of power, the loss of heating, loss of water, or other unexpected occurrences or events. So again, flooding, loss of power, things of that nature, whether it's a school, whether it's a senior care center, it's a number of things that could potentially be covered under this. So again, just something else to keep in mind, because it already permits employees to use paid sick leave for a variety of other health and safety concerns. So this, again, is just an expansion of that.
Okay, thanks, Carrie. So let's finish up our state updates, and then we're just going to briefly touch on some hot topics because we have 5 minutes to go and we are going to end on time. So Arizona had some updates to their minimum wage law. Now, as of the first of this year, the minimum wage has increased to $14.35 an hour, except for our one city in Arizona that wanted to be special and have their own, and they have a $17.40 hourly worker minimum wage for Flagstaff, Arizona, and a $15.90 for tipped employees. There's also some updated posters available for Arizona. We do assist our clients with posters, so any updates would have gone out as well, and be available to employers who have employees in Arizona. So let's just briefly focus on our hot topics and trends for 2024. And I'll kick us off and talk pay transparency. We've talked about, Colorado's law. We've talked about this move to be transparent in what job postings are out there, how much those jobs pay. We'll continue to see that go into effect in more and more states as states really want to pull that curtain back and let people who are applying for jobs know really what is available to them that they can negotiate for. And so more and more those job postings are more stringent in what they need to include. And so it's something to keep on your radar as potentially you move into new states to make sure that you are in compliance with that state specific pay transparency rules.
And another trend we're certainly seeing is data privacy. So really the increase on the consumer data privacy front. These data privacy laws continue to trend across the country as well. So employers should review their internal processes to make sure they have data privacy policies that comply with the laws in the states in which they do business. And again, they're very nuanced. So whether it's consumer related or minor, certainly there's a lot of data privacy laws that are targeted towards minors and the use of technology in the the consumer platform, if you will. So
and non-competes, we've talked a lot about this one, so I think it's on everybody's radar. We've seen a couple of states that we talked about today be moving and shaking on the non-compete front, California, specifically Washington, and other states as well. So we're going to continue to see it. I've heard rumblings that the federal, on the federal level, they might try to do something with non-competes, but I think like we see in other areas, it's going to happen on the state level and is happening on the state level first, and maybe at some point federal will be able to step in and kind of reset the standard for everybody. But for now, just keep in mind, if you're going to have a non-compete, it is a useful tool, but you want to make sure that you understand your state's specific laws for them.
Final slide very quickly here, the paid family leave funding. We do continue to see states enact paid family leave laws as well and fund paid family leave through employee and sometimes employer contributions. So again, employers need to be very aware of the states they're entering and that they're in compliance with these laws as well.
Right. All right, so that concludes all of our many slides of topics that we discussed today. Shannon, I don't know if you're with us to wrap us up here.
I sure am, Liz. Thank
Awesome.
you so much to Liz and Carrie for this jam-packed and valuable presentation. And thank you to everyone for joining us. You can view this webinar recording on our website by visiting prestigepeo.com/webinars. We did get some questions, and I will send those on over to you, Liz and Carrie, for your response. Be sure to check your inbox for our monthly Insights newsletter, which will give you the latest HR news information you need. And you can also reach out to your HR business partner for additional guidance and explanation on the topics covered. You can also follow us on Facebook, LinkedIn, Instagram, and Twitter for current happenings at Prestige PEO and the latest information. Finally, remember to download our Prestige Go mobile app for access to your benefits information and support from your HR team members on the go. Thank you all, and we'll see you next time. Bye, guys.
Thank you. Bye-bye.